Hello, Vince DiStefano here from Property Snaps. Today I'm going to touch really quickly on copyright and image usage. So one of the most common misconceptions that we hear out there is that when a vendor pays for marketing, and in particular photography, they are of the belief that they actually own the photographs and they can do what they like with those photographs. Now, in most situations, this is not necessarily true. A vendor can pay for photographs to have for selling their house, but that's a licensing arrangement. So it's a bit like a ticket to ride the bus. You can buy a ticket to ride the bus. It doesn't mean you own the bus, and it doesn't mean you can bring your friends on the bus on that ticket. It's the same in real estate. So when you sell photography services to a vendor, they are generally paying for a photography service. So the images can be used to sell the house for the life of the campaign. They can't be transferred to another agency, they can't be resold, and they can't be used for other purposes without written consent from the copyright holder. So who is the copyright holder? All right, well in Australia, by default, the person that pushes the button on the camera, the photographer, is the copyright holder by default. You may have different arrangements with your current photographers where they don't have a licensing agreement, which is great. But it also can work against you too. You may have a fantastic photographer and that photographer is part of your brand and your image. You don't want another agency to be able to capitalise on what you've discovered or what you're benefiting from. So having a licensing arrangement with your photographer is extremely important. To give you a potential scenario, you've listed a property, the property hasn't sold, the vendor's gone to XYZ agency up the road. XYZ has listed the property and the vendor said, look, I've already paid for photos. The photos look really good. Can we just use those? XYZ's completely unaware that they don't have permission to use them. They put them up online. They've now breached copyright. Now, the potential cost of breaching copyright can be really, really, really expensive. I know of one particular case whereby a property manager used some photographs which they found on Google or one of the websites to market a property for rent. The photographer that took these pictures worked for another agency. They then issued this agency, the rental agency, with a copyright breach notice. Now, the fee for breaching a copyright on an image is dependent on the photographer themselves, but that fee may range anywhere from a few $100s per image to $10,000 per image. So it's a pretty wide gap. In this particular case, there was 15 images and the agency got some legal advice. The legal advice was, we don't want this to go to court. Here is 10 other cases where the photographer's won. We should arrange for an out-of-court settlement. The settlement amount was north of $50,000, so it was an extremely expensive mistake, which could have been solved by ordering a rental photography shoot for a couple of $100. Instead, it costs the agency or their insurance company 50 grand. So what can you do as real estate agents? Right, so to protect yourself, if you've been given some photographs from a landlord or a potential vendor, you need to find out if you have the rights to use those photographs. So to find out if you've got the rights, you either call the previous agency or you call the photographer directly to ask if you can have the rights to use the images or if they'll sell you a license to use those images. In most cases, most photographers are pretty reasonable. They'll sell you a license or they'll give you the license to use them. If they're tied in with an agency and they're part of that agency's brand and that brand is protected, then they may also deny you the license and you'll have to go and fork out, or the vendor will have to go and fork out for some photos again. But it's a lot cheaper than forking out for a legal case. On the other side of the coin, if you're providing your vendors with photography services through a photography company such as us, you need to have some kind of disclaimer on your marketing schedule that states what your terms of arrangement are with your photographer. So that disclaimer may simply say photography belongs to XYZ company, images may not be resold or retransferred without written consent. So just a short disclaimer that you point out when they're signing their marketing schedule. And that protects you too, because in some cases, a real estate agency may say to the vendor, look, here's your photographs that you've paid for. There you go, you can use them. If you put that in writing, then that opens you up to a legal case as well, because technically you've passed on rights to something that doesn't belong to you. So you may find that if that vendor gets sued, or if that agency gets sued, they may counter-sue you for providing them with a false license as well. So really important, guys. Copyrights, you know, the courts are cracking down on in Australia. It does get extremely expensive when it can be avoided by just reshooting the property. I know in some situations, you know, tenants may have moved in and the house doesn't look good anymore and it's not possible to reshoot it. In that situation, then either try and seek the licensing arrangement to use the images. Otherwise, you have to look at other options like digital decluttering and things like that. So protect yourselves by finding out if you've got the rights, and protect yourselves by having a disclaimer on your marketing schedule. If you've got any questions about copyright or licensing, I've been on both sides of the fence of it, so I am experienced. You're more than welcome to shoot me an email. My email is vince@propertysnaps.com.au, and I'm always available to answer any questions that you may have. Thanks for watching.